Before we start here today, I want to have a little moment of silence for a young man that visits us quite often, Kenny Bilbrey. Kenny loved the courtroom and sat up here and observed the light. He was a sweet soul. May he rest in peace. Bow your head, please. Thank you very much. Commonwealth versus Troy Albertson.
Right, this is a quick one review, really, just to make sure that Mr. Allison is making the restitution, and we're just wanting to continue this out for 6 months, just so make sure it's.
I'll continue it generally and y'all can redocket it, okay?
Thank you.
Commonwealth versus Daniel Boston. Are you Daniel Boston?
Yes, sir.
Born in 1982.
Yes.
Last 4 digits, social security number 9048.
Yes.
You're here for a pre-trial conference.
Yes, sir.
Yeah, we're just
You
wanting
step over this way a little bit, sir.
to continue this, and
When is that trial scheduled?
October 17th and 18th.
It's October 17th and 18th. So let's put him on for November 2nd. Commonwealth versus Brett Carver. Are you Brett Carver?
Yes, sir.
Born in 1976. Last 4 digits, social security number 5893. Okay. You're here today for the purpose of arraignment. You're represented by counsel. You have the right to remain silent. The grand jury of Clinton County has returned an indictment, 2-count indictment, charging with theft of unlawful taking. Amount 104,000 and they count 1, and amount 108,000. You count 2, making them Class C felons. You understand those charges? Counselor, you acknowledge the identity of the client received indictment. Waive formal reading and arraignment, enter plea not guilty, reserving all pre-trial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order. Mr. Carver, with the Commonwealth has provided you with the information they have about your case. When is the negotiation day?
Your Honor, finally, take your check. This was a bit complicated, as you might gather from just looking at the indictment and the nature of the relationship between Mr. Carver and the victim. If we can get a little extra time, it would probably be good. And this is not the only thing that's got going on as well. So whatever the court feels.
Commonwealth want to come around? Now, I've just signed a reciprocal discovery order. Do you feel like you have sufficient information to proceed with this, or how do you feel?
I'm not familiar with it.
Okay. So what I'm going to do is I will put this down for November the 2nd. What's the negotiation day in late October? If you got one yet?
October 9th is the next, it's October negotiation day.
Well, you won't need. It wouldn't hurt to be there on October 9th, just to see how you're progressing. October 9th, and then the next court date will be November the 2nd, unless you have a resolution before then, okay? There's no complaints about Mr. Carver's bond.
No.
Okay, you can remain on the same bond then. Commonwealth versus Jamie Harold.
Conference call. Before they make that call on October.
That's what they said. Jamie Harold. Bench warrant. Warrant not been served, is that right?
This one's.
Has the warrant been served?
Yes, we had both the bond and they said it was, but they're 14th and 9.
Okay, you need to start efforts toward bond forfeiture on that and issue a bench warrant. Tyler Holland. Commonwealth versus Tyler Holland, 23 CR 0040. Are you Tyler Holland? You born in 1996, last four digits, social security number 0698. You're here today for the purpose of arraignment, 23 CR 0040. You have the right to remain silent. You're represented by counsel. Grand jury of Clinton County's returned an indictment, sir, charging you with failure to use a seatbelt, operating motor vehicle with an expired license. Not have a license in your possession, failure to maintain insurance, trafficking controlled substance, possession of drug paraphernalia, tampering with physical evidence, and being a persistent felony offender as far as the trafficking case. Do you understand those charges? Acknowledge the identity of your client, counselor, receive indictment, wait formal reading and arraignment, enter plea not guilty, reserve all pretrial motions.
Yes, Your Honor. Your Honor, at the point,
Signing a reciprocal discovery order. Go ahead. Excuse me.
at the point where I was limited to know the board and record, and I represent, DBA representing Mr. Hall, the vote before, so I said.
Yeah, I continue. I saw it. Hey, what is the, you said the negotiation, it was on the 9th, October 9th, and the next court date, October 12th. Okay. Thank you very much. No complaint about Mr. Holland. Court's in bond, may be released on your same bond. Okay. Okay. Commonwealth versus Tony Lahorn. Commonwealth versus Tony Lahorn. Then it seems to be an active warrant on Mr. Lahorn. You want to check him into NCIC? Commonwealth versus John Maynard. Seems to be an active warrant on Mr. Maynard, NCIC. If y'all do a check on him. Commonwealth versus Christopher Pierce. This is 23 CR 0038. Are you Christopher Pierce? Born in 1981. Last four digits, social security number 9875. You're here today for the purpose of arraignment. Do you understand that? You have the right to remain silent. You're represented by counsel. You're represented in district court by Office of Public Advocacy. Also, I'll continue that appointment. The grand jury of Clinton County has returned an indictment charging you with possession of controlled substance, first degree methamphetamine, obstructed windshield violation, failure to maintain insurance on a motor vehicle, and expired plates. You understand those charges? Yes. Counselor, do you acknowledge the identity of your client received indictment? Wait formal reading arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
We'll set this for October the 9th for 1 o'clock for a pretrial, for a negotiation date, October 12th, the next day. Both of those are conditions of your bond. I'm signing a reciprocal discovery order. The Commonwealth will be providing your attorney discovery That'll help you prepare for your case. You'll be continued on the same bond.
Thank you, Your Honor.
Andrew Ridge. Andrew Ridge. Combo Executive versus Andrew Ridge. 23 CR 0033. Are you Andrew Ridge?
Yes, sir.
Were you born in 2003?
Yes, sir.
The last four digits, your social security number 5010. You're here today for a pretrial conference. 23 CR 0033. What does the Commonwealth have to say?
Your Honor.
Okay, this is a
Virgin.
version, please. Okay. Motion has been tendered today, sir, that says you wish to enter a plea. Is that correct? Are you currently under the influence of drugs or alcohol? This is plea freely and voluntarily given. Are you the same person named in indictment 23 CR 0033? Is your judgment impaired today in any way? Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence which the Commonwealth has against you? You believe that you've been fully informed about your case. You understand that you do not have to enter a guilty plea. You have certain rights under Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes, sir.
I'm going to go over with them and I ask you to affirm that at the end, okay? You have a right not to testify against yourself. No one can make you say anything. Your right to a speedy trial by jury, your right to be represented by counsel at your jury trial, right to be confront and cross-examine all witnesses called to testify against you, or produce evidence, right to call witnesses in your favor, have process issue, compel evidence. You have the right to appeal this matter to a higher court if you lose. And you have a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. You understand that by entering a guilty plea today, you give up those rights. And I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. In the event that I don't accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea and go to trial.
Yes, sir.
I'm going to ask you some qualification questions here. Have you previously been diverted in the last 5 years? You have felonies in the past 10 years? Are you on probation now? Okay, you understand that if you fully complete the diversion program, the case will be dismissed, pre-trial diverted, you expunge your record, you understand that? But if you do not complete the diversion program and you're revoked, be brought back before the court. A pre-sentence investigation report will be ordered and you'll be sentenced. You'll be a convicted felon. You understand that?
Yes, sir.
In that case, any future felony convictions would be enhanced. You understand that?
Yes, sir.
The Commonwealth come around with a recommendation, so you step to your left. Let's go, Anderson.
Yes, Your Honor. Upon a plea of guilty to criminal mischief first degree, the defendant shall receive a sentence of 3 years, pre-trial diverted for 3 years. Upon a plea of guilty to failure of insurance on a vehicle, having been paid a $500 fine and cost. The defendant shall have no contact with the victim. The victim's business. Then shall pay restitution in full amount of $6,575.99 plus an additional 5% purchase fee. Payable to complete until the court department within 45 days of the entry of said plea. The Commonwealth has no objection to removal of home incarceration provided the court approves. The defendant shall complete the inspector program. Then shall obtain gain of employment of a minimum of 30 hours from services to gain for employment obtained. The defendant agrees to have email evidence in the most style case so that the name of law, Commonwealth and the whole agency.
Is that your understanding?
Yes, sir.
Has he been admitted to the specialty court yet?
He has not been in his recommendation.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
You plead guilty of your own free will because you are guilty for no other reason.
Yes, sir.
Knowing your constitutional rights, explain to him that it's still your desire to give those rights. Enter plead guilty and allow the court to fix your punishment. Okay, is that your signature on the document? And on the restitution order also?
Yeah, I brought it today.
Okay. Now, is he on an ankle monitor now?
Yes, Your Honor.
Well, I'll take the ankle monitor off when he gets into drug court. As soon as you get into drug court, I'll take it off. And so I'll sign this referral today.
Yes, Your Honor.
And then you'll go under their auspices and you won't be, our pre-trial and at that time. Okay. Okay, I'll accept the agreement, sign the diversion order and sign the restitution order and the referral to drug court. Now, when should she get in contact with Mr. Cross as far as drug court? No, could y'all text him and tell me? Okay. You just need to, and they'll tell your lawyer and you need to stay in contact with him, okay? Hey, thank you very much.
Thank you.
Yeah. Christopher Young,
Judge, on this one, he agreed to submit a pre-trial version and the paperwork was misplaced. And it's been recommended this thing. So he was here to read and
That's
everything.
what we're looking for, Your Honor, so that's all we need to done on it.
It just needs to be signed over Mr. Cross.
did we go through it last time?
Yes, he's already entered it and everything. You
Yes.
just didn't
We
get
just
there.
couldn't find the paperwork, and I found it.
He appeared
Like,
at Rose.
he's been here just left, because he's already been gone. I was in 5 minutes ago.
Let's keep that with us when you sign. Okay, the documents have been found, mysteriously appeared, he had previously entered a plea with us, pre-trial diversion. Now we've got a Cumberland County case that's scheduled at 10 o'clock. The next things we have are 10 o'clock. The Dare County, are you on there yet? They're not on there, so Russell County on the line there. Russell County, we'll go ahead and take your case up. Mr. Wilkerson, you don't have any problem with us taking the case early, do you?
No, I was, there's just a little bit of paperwork that needs. Right.
Okay. Hey, hey. Russell County, I'd call Nancy Rains. Nancy Rains. You need to tilt the camera down a little bit there. That's
There you go.
better. Commonwealth versus Nancy Rains, 22 CR 006 Are you Nancy Rains?
Yeah,
What year are you born, Miss Rains?
2001.
Last four digits of your social security number is 0300.
Yes,
We're here on 22 CR 0067. Your attorney is consulting with the Commonwealth right now. What does the Commonwealth have to say? Is it a felony plea?
Version of your- the version of that. Oh.
She's got it now. Ms. Raines, I understand that you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily entered?
Yes.
Are you the same person named in indictment number 22 CR 0067?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney?
Yes.
Are you satisfied with her advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you and you feel like you're fully informed about your case?
Yes.
You have certain rights under the Kentucky and United States Constitution. As you're aware, you do not have to plead guilty today. I'm going to go over those rights with you, and at the end, I'm going to ask you if you understand them.
Okay.
You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea, you give up all those rights. You understand that?
Yes.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept their recommendation. In the event that I do not accept their recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Now, I've got some qualification questions I need to ask you. Have you previously been diverted in the last 5 years?
No.
Have you felonies in the last 10 years?
No.
Are you currently on probation?
No.
You understand if you fully complete the diversion program, the case will be dismissed, pretrial diverted, and you can get your record expunged. Do you understand that?
Yes.
But if you do not complete the program successfully and I order a pre-sentence investigation report to sentence you, you'll be a convicted felon and future sentences could be enhanced because of that. Do you understand that?
Yes.
But what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to receiving stolen property over $1,000, the defendant shall receive a sentence of 5 years, serve 90 days in jail with the balance pretrial diverted for 5 years supervised. The defendant shall receive credit for time served. The defendant shall have no contact with the victim, victim's real property, or victim's immediate family. The defendant shall enter and complete the Clinton Specialty Court. The defendant is currently incarcerated and shall be released from incarceration on the morning of specialty court orientation. Upon completion of specialty court program, supervision shall be inactive. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above styled case disposed of in a manner with the laws of the Commonwealth and the holding agency.
Ma'am, is that your understanding of the Commonwealth's recommendation?
Yes.
Are you pleading guilty?
Yeah.
Because you committed the acts charged, is that correct?
Yeah.
You're doing so of your own free will because you are guilty. Is that correct?
Yes.
Okay, knowing your constitutional rights to explain it to you, is it still your desire to give up those rights, enter a plea of guilty to the charges and allow the court to fix your punishment in the range permitted by law?
Yes.
Correct.
Yeah.
Okay, is that your signature? Let me have the document here and get me approach here. Is that your signature there?
Yes.
Okay, will you date this? Well, I'll accept the agreement, sign a diversion order. Is the referral for special court in this group of documents too?
It is already been heard, Judge.
She been voted?
Been voted on. And-
Okay, well, when is the orientation?
Monday
Okay, well,
at 10:30 here.
okay, well, I'll let you out at 9 o'clock on Monday morning. That way you can go. Do you have a home to go to now, young lady?
Yes.
Okay, that way you can go home and clean up and everything, so you can present yourself at a special court, okay?
Thank you. Thank you.
Thank you very much. Russell County, you have anybody else over there for us?
There's nobody else in here, but I don't think there's anybody else that
Okay,
needs. Okay,
thank you very much.
Thank you.
Yeah. No, we don't have anything else scheduled to 10.
Your Honor, on I actually did have Clinton County bring over Justin Gibson, he has a probation verification hearing. He's actually back, behind the scenes.
My brother, Mr. Harold, straight up. Like Jamie, this straight up. He's the one that couldn't be, he should really wrestle in that.
Okay, we can bring Mr. Justin Gibson out then. Commonwealth versus Justin Gibson, 21 CR 00107. Are you Justin Gibson? You born in 1989? Last four digits, social security number 6589. You're here today for a probation revocation. What does the Commonwealth have to say? Knock on the door back there. This is Mr. Justin Gibson. He's here on a probation revocation.
Yes, Your Honor.
If you move to the left here, move to the left. It's okay.
Your Honor, this is our motion for
You need to
revocation.
speak up a little bit.
This is our motion for revocation, but I think that we reached some type of agreement. I think that Mr. Gibson is going to go into specialty court. We're going to continue this.
What were the violations that you?
Now, I guess, Judge, provide a little clarity, Mr. Gibson went to rehab in September of 22. Started in March, late March, but he actually almost completed the term of the school probation. We're not wanting all of it, it's actually that he's gone. And this one, he's looking to implement tools that he learned in rehabilitation. He does in special. We have productive in society.
Where was he? From the day he left the rehab, so how long has he been in jail?
Almost 68. Picked up in July. I want to say it was July 11.
Had to be extradited?
Yes,
Yeah. Ain't gonna happen. So. We can have a hearing on it. So we'll schedule a hearing for next month.
We actually scanned.
You prepared for the hearing today? You prepared for the hearing? Comma, prepared, okay, to call your witness.
And Kenny Ross.
Yeah, right up here. You raise your right hand, you swear the testimony about to give us the truth, whole truth, and nothing but the truth. You lean toward that black box there. State your name, with whom you're employed, and what capacity. You need to speak up now.
Okay.
Okay.
And as part of your duties, as probation pro, did you supervise justice?
You gotta speak up.
I just took the case of the 50, so I'm not that looking at, but is he on your case list for that, and was he being supervised by probation? Yes. during his probation for loss of was. Susan is 60, and then, you had a chance to review her report. I thought he was over judge when he first, went on supervision. March the 4th, 2022. And, since that time, has he had any violations? Yes. He was so court with his violations. Current violation was excluding his whereabouts from,
I'm sorry, I cannot hear you. You're gonna have to speak like your outside voice, okay?
He concealed his whereabouts as of February 19th, 2023, violating Edgewater recovery. That's February the 19th. Yes. Yes, when he left Edgewater recovery. Yes. Did he have any other type of violation after that? He failed to report to us as well after he left there. We told him if, after he left, we have. They usually send an email to the office. I'm not sure if that happened. I'm sure it did, but I can't say, when was the next time that we heard from Mr. Dixon? With our justice exchange, we can pick that up. When was he did that? We hadn't had that date in here. Are you aware of where he was, picked up from? That's all the questions I have with this, and some call,
And again, what was your name, ma'am?
Meeting wrong.
Ross. You're wrong, this is first, I'm not with you, so you're new to the job, right?
Yeah.
And just to rehash what you just said, but you can't tell us the date of this alleged violation.
The day that. On February the 19th, 2023, was when we left treatment.
Okay, that's when
That's today's violation.
right, and that's when this email was sent, or you didn't know about it.
We did. They usually always send an email, but I wasn't not his officer of the company.
So that February date, you know where that came from?
In the violation, it just said that on February 19th, 2023, he left treatment.
No narrative as far as who's reporting that. And if there's nothing,
Just a report when he left treatment.
and there's nothing noting who from Edgewater is telling you.
Not in this violation.
And the absconding, and it's subsequent to that, connected, not reporting you.
Yes.
That's one violation.
Two, was when he was in treatment. We need to tell us where he was.
Okay. Now, as far as Mr. Gibson. He's on probation, is that correct?
Yes.
Now, are you sure that he wasn't in pretrial diversion?
Probation was very good. On March the 4th.
But you're not sure if that's diversion or probation, you're saying what it shows us probation.
It's shows probation too.
Would there be different signification if it was,
We would say
Diversion.
diversion.
would it say pretrial diversion if it was in fact?
Violations, yes.
Okay.
Violations of diversion, oral probation,
That said probation, not pretrial diversion.
yes.
Thank you, Mr. Ross. Those are all the questions I have.
You have any redirect?
No, Your Honor.
Let me stand down. You have any other witnesses? The record does show that he was on probation. You have any further witnesses? Counsel, would you like to call the defendant or anyone on his behalf?
I'd like to call the. Do I can testify from table?
He can come up here. Best you can, will you raise your right hand? You swear the testimony you're about to give us the truth, the whole truth, and nothing but the truth. Sit in the seat there, scoot forward, state your full name into that microphone there.
Just you've been sitting here the whole time, right? You heard everything Mr. Ross said.
Yeah.
Want to fill in some pieces and what I want to start with is taking us back to when you went to Edgewater. Remember when that was?
March 15th, or September 15th,
Of
2022.
Was this a long term, short term, what type of rehabilitation was?
It was a long time. 6 months.
How did the rehab go?
It was going great, honestly. The only problem I had, I passed the blood test, never had a problem with blood test, anything like that. The only thing was, is that we needed to get into the NAUs and, build a split group, with rides and stuff like that, and, we didn't have the transportation for the NAUs a whole lot, so we had to do them in-house and stuff, and, my sponsor at the time, was working there, and then he's only there a few weeks before, I faced to the third house where I had to get a job, and he went to work on power lines again, so he was back on the road working 12 hours. So the only couple of rides I could get was very few, and I had a problem with curfew for coming late from work from Subway, and it got to where I had like 2 or 3 of them. This is the problem.
Let me, say a lot, I don't want to unpack that. So, in part of your rehabilitation in Edgewater, you had progressed from whether it was leaving Cohop and working somewhere?
Yes.
So is that phase and steps, how did they work?
There's phase 1, which is like a detox, we go in for 30 to 45 days, and then go to phase 2, and that's when you take classes. And then at that time, when you're taking classes, they allow you out from 5 to 9. As long as you're required to get an NA in while you're out from town or whatever. And then phase 3 is classes from 8 to 12, and then from 12 to 9, you were required to work and get a job.
Where were you at?
I was basic.
Because you were, as you said, about finished.
I was a week away from it when the problem occurred.
So just, you know. So be our question, why did you leave in February?
Well, when they threatened to kick me out, it was just a fear, overwhelming fear that I had, and it was like more of the not knowing. And I made a rash and bad decision, that's all it was.
March of 2023, so a few months. What'd you do?
I was around here,
37.
scared. I've been in prison before and stuff, and it was, my grandma was sick, so I was trying to see her, but I didn't know what would happen.
During this time, you're on the land. Were you using?
No,
Just in your others, you can use your others during that time.
no,
You're doing this right now, you can pass a pair of off, go back months. See if you're using your others. Were you working, or you think money during that time?
I was doing a lot of things, I was like little construction jobs.
And statements on the record, I'm gonna say this, but statements on the record that you picked up in the state of Indiana,
Yes,
Why were you in Indiana?
My grandma recently been removed from the nursing home she was in, and they moved back up there, and at the time, she had went in the hospital, and they had, she couldn't come, and they didn't know she was out or not.
You have any other family members in Indiana?
My mom, but that's it.
So was it going to Indiana to hide or?
No, it was a weekend, it was a weekend trip. It was right before the girls, or my stepkids was starting school, so, I was going up to school started that way, I could get up there and see it without there being an issue with the missing school or anything.
So what's coming forward is at that point you weren't just living in Indiana, you
Was he telling the court or you telling the court this?
both your own.
Okay. Proceed.
Were you residing in Indiana when you got picked up? Yes. Given a second chance, opportunity. How would drug court be?
Well, here's what they taught me with counseling, going to any meetings, working with a sponsor, and what my step was that I could see it away from addiction, and I hear that drug court's a great opportunity to if they can tools into that, and I would like a chance to be able to continue sharpening those tools and go to my support group so that I could better further myself, more for myself, for my family, my fiance, and my stepkids.
Thank you, Dennis. Thank you, Your Honor. I have no further questions.
Counselor, you want for the Commonwealth.
Mr. Gibson, you went up long-term rehab, right? And you never contacted probation control, you left that, correct? And you picked up in Indiana in July, right?
Were there any charges in Indiana?
Just a driving while suspended.
So you're driving while suspended in Indiana and they just ran a license on you and found out that you were.
Yes.
Okay. You like to make an argument, counsel?
Judge, I was actually the one that has to call.
Okay.
Probation control officer.
Okay.
As well.
Okay, that'd be fine. You can stand down. It's your right hand, you swear the testimony you're about to give is the truth, the whole truth, nothing but the truth. Have a seat, lean forward, state your name.
Christy Conley with Commonwealth Department of Corrections Division of Probation and Parole.
Morning, ma'am. Please speak up just as loud as you can, so we can make sure we get a good record. I want to ask you, how long have you been with probation officer?
Since May 1st.
A little bit longer than. So I want to go a little bit through the procedure, just ask a few questions. But at the end of it is on probation and they're at a long-term rehabilitation. If they were failing drug tests or otherwise being a knucklehead, would you get notifications of that? Would those come through those emails?
Yes.
So
We get like status letters.
but, and again, if there were status letters that were negative, there would be a record of those in the report, which Ross read it, right?
If the officer puts them down.
Again, if we operate on the procedures not documented, not done, those wouldn't have happened, right? When you refer, or I guess, is everyone that gets on probation automatically referred into the rehab?
Not everyone.
How was that process?
So as a news supervisor, if there was a positive discrimination, first topic, I will be first. For whatever recommendation on for discrimination. And then, if they fail to do treatment at ILP, then it's usually inpatient. After that.
And, but they would have to agree to do those things, correct?
We could say,
So if person is not going to cooperates in probation terms and conditions, they would just say, I'm not going to rehab at all.
right.
You know, when you have an individual that is, what it is, like 5 months of long-term rehabilitation. As a probation and parole officer, what would be the next transition you would like to see? Let's say they didn't complete, let's say they almost got there and didn't finish. What would be your recommendation in a situation like that?
Well, they're always something. Once they open treatment, if they want to leave, they are directed to contact them. I'm not never been in that situation, but I can't remember the complete answer. I would just expect them to contact us and then they would probably refer back to the, to see what other treatment options are there.
You would take the approach, let's see if we can do more treatment.
I would staff it first, if someone looking at it before.
Ma'am, I know you weren't the optimism in Ross, but any board and program. People refer on special. Given what you've heard. You were given that seat. You deem that an appropriate.
You know, you think that's relevant, what she deems appropriate? And that my decision, what I deem appropriate?
Judge, I
I
think
mean, you asking for her opinion on what I should do based on what she's heard here today? I've never have heard that question before. I'm just asking.
I'm not going into 704. I guess what would be the truth is an issue.
Yeah.
Of course, you were here to decide. I'm just.
Go ahead.
I'm just thinking.
Just go ahead.
This hypothetical recommendation, this wasn't. Judge, I think it would be appropriate to ask that of Ms. Ross, given her time of the case. I can call her and ask her.
It's, you know, hypothetical what they would do. I don't think it's relevant myself, but go ahead and finish your line of questioning.
I would answer that in those lines of, and I've had that coming to represent the appearance for them, and just recommending to the person that represents them.
Sometimes that recommendation specialty court.
Hmm.
A lot of times, your case, that's recommended special court. No further questions.
The Commonwealth have anything?
No other questions.
Let me stand there. Do you have another witness you'd like to call, Council?
Yes, Your Honor, I'd like to let this recall Ms. Ross.
Okay. Still under oath.
Ms. Ross, when you're looking at cases, are you oftentimes asked to make recommendations on what could happen?
I don't have the training to do that. If I have a positive test, they're referred to SEC. If they don't complete that, we do evaluate you to the court and the judge and the Commonwealth, you know what's going on in the neighborhood.
In your time, have you referred in your month, have you referred anyone to special report? Not yet. As Ms. Cooney this, I want to make sure since you are in fact the worker. Besides the report of this stop. Were there any other emails or reports otherwise? That came from Edgewater?
There was nothing put in the violation.
Thank you, Judge. Those are all the questions I have.
Another question, John?
You may step down. You got any other witnesses?
No, Your Honor.
Would you like to make a statement?
I would, And Your Honor, my apologies, I'm looking at the case and thinking Mr. Gibson was on diversion. I know that's what he had originated as. Judge, I will still say, even if we're looking at the statute, what the statute for and presumptive probation. We've had, a young man complete 90% or better of a long-term rehabilitation. One report problem, but he left 2 weeks early. And came up on the stand and he articulated his claim to why. Talked about the tools that he gathered. And how specialty court would give him the opportunity to put those tools to use. I think he took accountability for the time that he was gone. He did talk about what he did in that community with family, sick relatives. But yeah, that he did acknowledge that he did wrong. Judges have been one violation. And
Well, let me ask you about his diversion. I was looking, he was on diversion. Correct?
yes, Your Honor.
Diversion, and he messed that up and got revoked. His pretrial diversion got revoked. Right?
That's presumably Your Honor, that was
Well, it appears you said he was on diversion. So his pretrial diversion is revoked, and he gets on probation, he gets sent to long-term rehab, and he leaves there and he absconds and doesn't report, and they've got to go to Indiana to get it.
Judge, I don't think he was ever on a pretrial.
He said he was. I don't know. Let's look at the record. He wasn't on a pretrial diversion. They say he wasn't on a
He
pretrial.
entered a plea of guilty on February 10th of 2022, and a
Yep.
judge was sentenced and a judgment entered on March 4th of 2022.
Yeah. So you had him in worse shape than he was in. So. Go ahead.
Now, again, leading to statute and contemplate probation at the first means to incarceration.
Which he was given.
What year?
Yeah, okay.
Judge, if he didn't intend to, yes, as I asked, just who, if got someone that doesn't intend to comply. If Mr. Gibson's intention was, I'm not going to do it. Probably would have walked off before completing. He might have been a problem. There would have been other reports. There would have been other problems. That this man is, coming to the board again, asking for special.
Thank you. Does Commonwealth have anything to say?
Just great honor, just reiterate that he has violated, and he couldn't put his long-term rehab, but early, he never contacted probation from. He got a new charge, on suspended, he had no intent to turn something until he was picked up. And we don't know what he did between February and July, because he was being with the last population. It's not special report. We did an option for him, we were able to put in a 6-month program, and we're able to simply contact probation programs.
Have we done a referral to him on specialty court yet?
We were just informed this morning.
Well, I'll tell you what I'm going to do. I'm going to sanction him to 120 days. And then I'm going to refer him to drug court. Okay, now, if they take a look at him, after the 120 days, they want him in there, I'll take a look at that. That keeps my hand on it. I'm not really buying what you're saying. Obviously, you're an intelligent person, you know, and you have a lot of excuses. And none of them seem, you know, completely valid because you knew you absconded, you knew that you didn't need, not only did you abscond, but you left the state. You might have had some good reason, but everybody's got some reason when they leave the state. Because why else would anybody want to leave Kentucky if they didn't have a good reason? So, you know, you're caught there. I'm gonna give you 120 days. The days that you have up to now since you were arrested will count toward those 120 days. And at the end of the 120 days, we'll determine on whether you go to drug court. If you're not accepted into drug court, I'm gonna just go ahead and revoke you and let you serve your time out, and this will be good time. I'm not saying it won't be good time, okay? Do you follow what I'm saying, Commonwealth? You know, he's gonna serve at least 120 days, counting the days that he's been in. We'll take a look at the drug court, and if they will accept him, even though he's a absconder, they might not accept him because he's an absconder. I don't know. Okay, thank you very much. Now, did we have someone that came in late? Jamie Harrell. Where were you, Mr. Harrell? Do what? I can't hear you. Commonwealth of Kentucky versus Jamie Harrell. 23 CR 0041. This is not your first rodeo here, is it? You've always been pretty good about coming. You've always been on time, so I'm not gonna punish you too much here on the thing. You're here for the purpose of arraignment. Mr. Harrell, were you born in 1977? Last four digits, Social Security number 3525. You're here today for the purpose of arraignment. You're represented by counsel. The grand jury of Clinton County has returned an indictment charging possession of controlled substance, first degree methamphetamine, possession of drug paraphernalia, trafficking controlled substance to the first degree, and being a persistent felon. You understand those charges? I'm signing a reciprocal discovery order. Government should give all the information they have to your attorney. So negotiation date on October the 9th at 1 p.m. and the next court date's on October the 12th. Withdraw the warrant.
Thank you.
Okay. Okay, we got Adair County is on the line. If you'll do up for Mr. Timothy Alexander. Nineteen CR 0042 and 23 CR 0039 motion for bond reduction. Commonwealth versus Timothy Alexander. You are Timothy Alexander.
Yes, sir.
You born in 1982.
Sir.
Last four digits of your social security number are 5227.
Sir.
Okay, what do you have, Mr. Poindexter?
Mr. Stockton and I had circulated a free order, at the court one motion, so. We're asking the court to release him on a, surety bond signed by his mother. And allow him to have, the incarceration while he's out. He's been incarcerated since May 10th of this year. The pretrial services report shows that he is a low FTA risk and a low NCA risk.
What are the charges against
It's an assault first,
him?
and the defense is going to be that it was a self-defense. That he had gone to both police officers and to the former county attorney asking for help from this man who is now claiming the case. And
Who is the alleged victim?
James England, I believe is his name. And, we're waiting on medical records.
What kind of criminal background is Mr. Alexander got?
The criminal center, sorry, the criminal record, I can, maybe this court that from.
Just go ahead, tell me.
I believe prior to this, the only thing he had was a drug felony where he was placed on pre-trial version.
Any other violent crimes to be kind?
Not that I'm aware of. No.
What does the Commonwealth have to say?
Your Honor, all I know is that Mr. Stockton did agree to a bond reduction and had signed an agreed order on it. And I think we were waiting on medical records, but we furnished those yesterday. And so that's our only position that I have from Mr. Stockton.
You have access to court.
He's still currently, even if you grant a bond on this case, he has no bond being held on a pretrial diversion violation. He was on pretrial diversion.
And that is correct, Your Honor, and Mr. Stockton had agreed to hold that motion to revoke.
Well, I mean, Mr. Stockton can agree. It's my decision. I want all the facts here.
Yes,
Right.
sir.
He was on a pretrial diversion when this allegedly happened.
Yes, sir.
I believe he also has a reckless homicide.
There's a reckless homicide on his record.
I'm not familiar with that, or if that's the same person, Your Honor.
Go over there and ask him if he has one.
See Timothy D.
No, Timothy White.
Okay.
Okay.
Do you have it?
I'm on this one.
That's different. Timothy Alexander.
Yes,
This was
yeah,
good.
reckless homicide's not him.
You don't have access to the instant report
Of the current case.
in this current case.
Yeah.
Let me take a look at the instant report. That'd be helpful. They alleged they went outside and got into an altercation, and your client started swinging a sword and cut him over his right eye with deep lacerations. That's what the allegation is.
Yes, sir. And our witnesses would testify that Mr. Hayward came to the residence with a metal pipe, come after Mr. Alexander.
So he went to a sword fight with a pipe.
Yes, sir.
Your client came to the residence with a sword.
No. My client was already there, living at that residence.
And had a sword.
Yes. Mr. Hayward came to his knowledge.
Well, I'll take it under advisement.
Yes, sir.
Okay. Thank you. Thank you, sir.
That's all I have.
In Adair County, I guess you can be excused now. Thank you for your cooperation.
Thank you. Have a good day.
Thank you. I guess we need to go to Clinton County Jail. Wayne County's not on there, correct?
Clinton County's not till 10:30. I don't know if anybody's there.
Clinton County is not on until 10:30. So will someone try to call Wayne County? They've got someone on for arraignment at 10. We'll go off the record for a second. Go back on the record, please. Commonwealth of Kentucky versus Jesse Pittman for the purpose of arraignment. File. This is 23 CR 0037 for the purpose of arraignment, and 23 F 62. Do we have, you gonna have a information on this one?
Your Honor, DPA representing Mr. Pittman below.
Well, on the indictment, it's got 23 CR 0037 and 23 F 62.
That's the corresponding estimate
Yeah, oh, okay.
when it was in district court.
Yeah, well, I thought it might be on there because they were gonna bring another one up with information, so it's not. Okay, are you Jesse Pittman?
Yes, sir.
You born in 1986?
Yes, sir.
What are the last four digits of your social security number?
5676.
Okay. You're represented by counsel. The grand jury of Clinton County has returned an indictment charging you with assault in the 4th degree, kidnapping, terroristic threatening, and being a persistent felony offender on the kidnapping charge. Do you understand those charges?
Yes, sir.
Okay, counselor, I'm sending you an indictment back to acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, in Commonwealth, I'm going to sign a reciprocal discovery order. Do you have a package ready for counsel?
Yes, Your Honor. I believe Ms. Vanderpool is going to bring it out there. Or take
We'll
it.
schedule this for the first negotiation date on October the 9th, 1 p.m. and the next court date on October the 12th.
Yes, Your Honor.
Okay, thank
I'll be able
you.
to see you, Mr. Pittman.
Okay, thank you.
Wayne County, thank you very much for your cooperation.
All right, thank you. Bye.
Let's go to Clinton County Jail. Call Thurman Eminette. Thurman Eminette. We have Thurman Eminette.
Yes, sir.
Are you Thurman Eminette?
Yes, Your Honor.
This is 23 CR 0034. Mr. Eminette, were you born in 1989?
Yes, ma'am.
Last four digits of your social security number 8767.
Yes, sir.
Okay. You're represented by counsel here today. I understand that you want to enter a plea. Is that correct?
Yes.
Commonwealth, is this a felony plea?
Yes, Your Honor, it is.
Mr. Eminette, as I look at the file today, it appears that you filed a motion to enter a plea. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment 23 CR 0034?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed these charges with your attorney and you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you and you believe you're informed about your case?
Yes.
You understand that you do not have to enter a plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes, sir.
I'll go over the rights with you at the end. I'm going to ask if you understand them, okay? You have the right not to testify against yourself. No one can make you say anything. Your right to speak trial by jury, the right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor. The right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of charges against you. Understand that by entering a guilty plea today, you give up those charges. You understand that?
Yes, sir.
Okay, now I may consider the Commonwealth's recommendation that I may apply any range of sentence allowed by law. I don't have to accept it prior to accepting the recommendation. I will order a pre-sentence investigation report to be done by probation and parole. At that juncture, I will make a determination. Now, counsel, will you, for the Commonwealth, state what the offer is?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years probated for 5 years supervised. Upon a plea of guilty to failure to maintain insurance on a motor vehicle as required by KRS Chapter 304, the defendant shall pay $1,000 fine and cost. The defendant shall enter and complete the Clinton Specialty Court and be released the morning of orientation. The defendant shall receive credit for time served. Defendant shall obtain gainful employment or do a minimum of 30 hours per week until gainful employment is obtained. The defendant agrees to have any and all evidence destroyed in a manner that is consistent with the laws of the Commonwealth and the holding agency.
What is the total cost of restitution and court costs in this case?
They're going to be $1,915.
$1,915. Now, you made an agreement on the restitution. What do you need on the court costs? Can you pay it now?
You need some time.
Yes,
You can pay it all now?
no, I can't pay it all right now.
Well,
I got a job if I get out though.
okay, well, I'll let you do $30. You pay your restitution and $30 a month towards your court cost. There wasn't a DUI in this one. There wasn't a DUI plea here, was there?
No,
So no insurance plea.
And it would be changed, I'm sorry, it'd be $1,155.
$1,155, okay. How much of that is restitution?
$1,000 fine.
It's $1,000 fine plus $1,000 restitution. Well, I don't know, I'm asking somebody to go over it
There's no
again.
restitution.
There's no restitution, or I thought I heard something about restitution.
It's just $1,000 fine. Plus court costs.
Does the Commonwealth listen to me?
Yes, Your Honor. We'll pull in the plea paper again to just make sure.
It's a possession sometimes.
Yes.
Judge, I don't believe there's any restitution.
Okay, so I'll let him do it at $50 a month. So it's $1,155.
Yes.
$1,155, you pay $50 a month first payment, 30 days from the date of your release. Now, is this understanding you had of the offer the Commonwealth made you?
Yes.
Are you entering this plea of your own free will because you are guilty and for no other reason?
yes, sir.
Okay, knowing your constitutional rights, is it still your desire to allow the court to set your punishment?
Yes,
Okay. Now, you understand if you have additional felonies in the future, the sentences could be enhanced because of persistent felony offender law. You understand that?
yes, sir.
And I have a plea document here. Is this it here?
Yes, that's it.
That's your signature there?
Yes, sir, it is.
Okay. Okay, I'll accept, order a pre-sentence investigation report to be done by probation and parole. And have sentencing on October the 12th.
Thank you, Your Honor.
Okay, thank you very much. Cody Daly. Cody Daly. Commonwealth of Kentucky versus Cody Daly, 23 CR 0006. Are you Cody Daly?
Yes.
You were born in 2002?
Yeah.
Last four digits of your social security number 7105. You're here today on a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, this is our motion to revoke based on a new misdemeanor charge, new felony charge, and some positive test on Mr. Daly.
You want to stipulate?
Mr. Daly, is that still your intention to stipulate?
Yes.
Okay, well, we will stipulate and we'll go ahead and do the revocation so we can get the good time behind them, okay? Thank you very much.
Thanks, Your Honor.
Yeah, this is.
That was a pretrial diversion. We'll send us a pre-sentence investigation report done and have the sentencing on October the 12th. October 12th for sentencing. Sydney Foster. Sydney Foster. Commonwealth of Kentucky versus Sydney Foster. Are you Sydney Foster?
Yes, sir.
You're on 23 CR 0022 and 23 CR 0043. 43 is an arraignment. So you're represented by counsel here. You have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you with 2 counts. Count number 1 is wanton endangerment in the first degree. Count number 2 is wanton endangerment in the first degree. Do you understand those charges?
Yes, sir.
You also are indicted for stuff. You're also indicted in a persistent felony offender. The first degree 7 counts as to attempt to commit murder, criminal mischief, wanton endangerment 3 counts, and tampering with evidence. Counselor, do you acknowledge the identity of the client? I'm sending the indictments back to you now. Receipt of the indictments, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Now, let me ask the Commonwealth, I noticed that this was a separately numbered indictment here, 23 CR 0043. It had 2 primary counts of wanton endangerment. Originally, it had 3. One of them was marked out and initialed, so there were 2 wanton endangerment charges. But then you had the PFO indictments. And do those PFO indictments have to do with a superseding or additional indictment on 23 CR 0022? Is that what they are?
All superseding, Your Honor.
Okay, well, I would like for you to take a look at those indictments and see if the original charges need to be repeated. We ran into a kind of a mess on that before. You have 2 indictments.
This is this case.
Yeah.
They,
Is this the one that's corrected it? I'm not really comfortable with the way I look at the indictment, and my staff lawyer will look
he was
over.
already indicted on the first indictment on some of those PFOs that they've included in the second.
That's what bothers me somewhat.
And Your Honor, the indictment I have is appears to be correct at this time. I know initially, excuse me, the wanton endangerment counts were to a police officer on 23 CR 43.
That was another issue.
Well, I'm gonna go ahead and let him enter the plea on that, but I think that counsel needs to look, defense counsel in the Commonwealth need to look at these indictments. I still think they need to be cleaned up somewhat. I understand if you take both of them and you're looking at them, but I think that you ought to be able to look at if it's a superseding indictment, I think you ought to be able to tell from this superseding indictment what the charges that have been enhanced under the PFO are. And I just didn't see that. Defense counsel, you agree with that somewhat?
I do, Judge, with the additional fact that, and I know we can take this up by motion if need to, it's the defense position that it should be a PFO 2, not a PFO 1.
Well, that's a factual situation. I'm just talking right now about.
But the correction, absolutely, Judge. It is hard to read and follow.
Yeah. Okay. Well, I think to make sure that the defendant's fully informed about what he's being charged with and which one of those charges are being PFO, that we need to look at that indictment. We might amend the indictment by agreement if you get that point. If not, it'd have to be presented to the grand jury again. Is it time for a negotiation on this case for the Commonwealth, or is it premature?
Judge, we had, to update the court, we had set a trial on this case. Then we received the indictment. You had ordered mediation in this case. It was unsuccessful. So from the defense position, we're ready to set for trial with the caveat we would like to understand.
Okay, I want to set this over to the next rule day again, to have the Commonwealth an opportunity to sit down with the defense counsel to look at these indictments. The indictment wasn't right, in my opinion, last time, and I'm not convinced it's right now. So we will set a speedy trial within a few days when we come back. I guarantee you that this delay will not shorten the amount of time it will be to his trial.
Thank you, Your Honor.
We want to make sure we get the indictment is correct, so this gentleman knows exactly what he's charged with. Okay. Thank you very much. Robert Harris. Commonwealth versus Robert Harris, 23 CR 0031. Are you Robert Harris?
Yes, sir.
Born in 1969.
Yes, sir.
Last four digits, social security number 3970.
Yes, sir.
Hey, you're here on a pre-trial conference. What does the Commonwealth have to report?
Just on Mr. Harris, we're going to continue his case to another negotiation day to see if we can get this one worked out. And we had entered into an agreement on his bond, which would be reduced to
What's he charged with?
Strangulation, first degree, assault, fourth, minor degree, 2 counts.
What was the agreement that you want me to consider on the bond?
The bond, modify it to $1,000 cash bond, and 11 o'clock curfew. With the
Okay, that's
exception
a strangulation case. Explain to me why this gentleman is not a danger to the public.
It has been brought to the Commonwealth's attention that the victim has been trying to contact the defendant. I think even went as far as going to the jail to see him. And so I think based on that new information, that's the reason why Mr. Stockton has agreed to amend his bond at this time.
I'm not going to do it. I need to have a hearing or something on it. I need the victim right up here. So,
Judge, can we do that hearing at your Monroe docket next Thursday?
Well, I don't know whether Commonwealth can have their witnesses there.
I'm not for sure either if the victim will be there. We can check. I can have the victim's advocate to get in touch with her to see if that is a possibility before the end of today's docket.
Okay, well, I want a written statement.
Okay.
And then the police officers involved need to be consulted too.
Okay.
So many times you have people that are victims of domestic violence that recant in some sort of way. And I don't always trust their judgment as to whether prosecution should be proceed or not. The crime is not a crime against that person, but it's a crime against the peace and dignity in the Commonwealth of Kentucky. That's who the charge is. And I take the strangulation, attempted murder, all these sort of things very seriously. Okay, next person is Jerry Kempton, is that right?
Yes, Your Honor.
Injuries.
Yeah, I'm just gonna finish down through this. Did I skip anything? Commonwealth versus Jeremy Kempton, 23 CR 0030. Are you Jeremy Kempton?
Sir.
Were you born in 1981?
Yes.
Last four digits of your social security number, 2874. 2874?
Sir.
I can't hear you, man.
You want to speak up?
Yeah, it's correct.
Okay. You're here on a pretrial conference. What does the Commonwealth have to say?
Your Honor, we're almost ready on this one, possibly for a plea. We were waiting on his medical records. We received those, I believe, maybe Monday. Mr. Stockton is just wanting an opportunity to look over them and see about some medicine that he's going to be prescribed. And we may possibly be able to take this one up on Monroe docket next week.
I'm going to schedule it on October 9th for a negotiation and October 12th for the next trial date. If you want to schedule him at one of the other rule days before then, we'll consider that for a plea.
Thank you, Your Honor.
Cody Owens. Commonwealth versus Cody Owens, 22 CR 0031. Are you Cody Owens?
Sir, Your Honor.
Were you born in 1987?
Yes, sir, Your Honor.
Last four digits of social security number 5351.
Yes, sir, Your Honor.
You're here today on a probation revocation. What does the Commonwealth have?
Your Honor, there was a hearing held on this revocation last month, and the court continued to see if Mr. Owen would be accepted into the Clinton Specialty Court, and he was not. So we're asking for revocation for him. I believe testimony was taken by Probation Pro last month as well.
It would appear to me I was willing to take a chance on drug court, but if they will not accept him, I'm going to go ahead and revoke based on the testimony I previously had. I just think that he is not, it's not conducive and he's not cooperative as far as supervision. So I'll go ahead and enter the order. Thank you very much. Lucas Pettinger. Commonwealth versus Lucas Pettinger. Are you Lucas Pettinger?
Yes, sir.
Were you born in 1987?
Yes, sir.
Last four digits of your social security number is 0933.
Yes, sir.
You're here on 23 CR 0026 and 23 CR 0025 for pretrial conference. What does the Commonwealth have to report?
We have a felony plea, Your Honor.
I find a motion here, Mr. Pettinger, that says you wish to enter a plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily entered?
Yes, sir.
Are you the same person named in indictment number 23 CR 0026 and 23 CR 0025?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed the charges against you with your attorney, and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Do you believe you've been fully informed about this case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and United States Constitution. Before I can accept a plea, I need to know that you fully understand those rights. I'm going to go over the rights at the end. I'm going to ask you if you understand them. You have the right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury. The right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. And the right to require the Commonwealth to prove on a reasonable doubt you're guilty of charges against you. You understand that by entering a guilty plea today, you give up those rights. You understand that?
Sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I don't have to accept the recommendation. Prior to accepting a recommendation, I will rate the precinct's investigation report from probation parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Do you understand that?
Yes, sir.
Ms. Gordon Anderson, will you give us the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to indictment number 23 CR 25 for the charge of strangulation, second degree, and PFO, second degree, the defendant shall receive a sentence of 10 years. Upon a plea of guilty to indictment number 23 CR 26 for the charge of possession of a controlled substance, first degree, methamphetamine, the defendant shall receive a sentence of 3 years. The 10-year sentence in indictment number 23 CR 25 and the 3-year sentence in indictment number 23 CR 26 shall run concurrently for a total of 10 years, serve 9 months in jail with the balance probated for 5 years supervised. Defendant shall enter and complete the Chad's Hope Rehab Facility. The defendant shall receive credit for time served, and the defendant agrees to have any and all evidence in both above style cases destroyed in a manner that is consistent with the laws of the Commonwealth and the holding agency.
Is that your understanding, sir, of the Commonwealth's recommendation?
Yes, sir.
Are you entering a guilty plea because you did commit the acts as charged in the indictment as amended?
Yes, sir.
You're doing so of your own free will.
Yes, sir.
Knowing your constitutional rights, as I've explained, it's still your desire to allow the court to fix your punishment in the range permitted by law. Do you understand in the future that if you have any other felony convictions, these convictions can be used to enhance the penalty under persistent felony offender law?
Yes, sir.
Okay. Is that your signature on there?
Yes, sir.
Going to go ahead and date it. I accept the agreement order pre-sentence investigation report. Have sentencing scheduled on October the 9th. Excuse me, October the 12th. October the 12th. Alfred Silva. Commonwealth versus Albert Silva. Are you Albert Silva?
Alfred Silva.
This is 23 CR 0012. We're here for a pretrial conference. What does the Commonwealth have to say?
Your Honor, this is our motion for release of certified copies of medical records.
Defense has no objection, Your Honor.
Okay, we'll enter an order. Now, is there a trial date set for this?
Judge, there has, we had set a trial in the past and we were under the assumption there was no medical proof in. Now we're starting to get medical records, so Judge, we do intend to retain an expert and they'll have to see these records, so it's.
Come on, I can't hear what they're saying. They're talking
No
to
one's
each other.
saying, no one's saying anything right now.
Oh.
So, Judge, I don't know the content of what these records would contain, or if Commonwealth wants to give a proffer, but again, without knowing the content.
We'll be back here on October the 12th. And either on that day, we'll either have a plea or set a trial date, and it won't be too far out, okay?
Yes, Your Honor.
Thank you. Now, is there anybody else there at the Clinton County Jail that we haven't talked to that's on the docket?
No.
Okay, you're excused. No one else in the courtroom that finished it? You got somebody else? Okay, bring your grand jury in. Let's go off, right? So Albertson versus Albertson.
We have an agreement with this guy.
Cooksey versus Cooksey.
Step in, but that Albertson that you all gave him was 17, yeah, 63. And
Judge of office in the install, this is the rear is only. The rear is 5820. Asking that they will be paid by office. Office. Thanks. Judge, Mr. Cooksey's case, here, is 4252, and the last payment was $800. April, and to the pay, away from the current 50 of arrears, and we're asking for 1,000 to be paid by October the 11th. Mr. Cooks had mentioned about seeing the child in visitation, if he realizes he has to get a private lawyer, and that don't have anything to do with what we're here today.
Room full of them here.
It's a very good one. I made one that I.
Are you out of luck? Thank you very much. You need to. Okay. Van Winkle versus Van Winkle.
Judge, in this case. That's me to pay, current 500 years and the rest of the payment.
Versus versus Cross 15 CI 00164.
Judge, in this case, we're to pay $200 to a month of current 25 on arrears. We're asking $1,000 to be paid by October the 11th.
Cabinet versus Holston.
Governor, in this case, we have an agreed order.
Versus Albertson.
That was the agreed order.
First document. Cabinet versus Anderson.
This is a motion, for to establish child support if I need to add. Never mind, Judge, I'm struggling here. This is a hit a motion, price $613. We're pay, $450 a month in current, we're asking $1,000 to be paid by October the 11th.
Versus East.
This is the previous say child support previously in order to then establish a rate for employee, they also have a lower current or asking it to be reinstated.
Guffey versus Guffey.
Just as a, also to amend, the child support obligation of the children, and that's paid, judge. That need to provide an order and one. Figure.
Ford versus Anderson.
Judge, this is the Anderson's order for the staff with house. Like it's the one child, then the one judge, that's the one thing.
Cabinet versus Young.
Judge, we have an agreed order in this case.
Cabinet versus Crawley.
Yes, Ms. McCrollum is here, and she's here all. Establish child support. I need 70, that's. That's more than this.
You want to step a little bit to the left, let the witness get behind you. You raise your right hand, please. You swear the testimony about this truth, whole truth, nothing but the truth.
I did.
Lower your hand, state your name with whom you're employed.
Stephanie Wyndham, caseworker, Clinton County Child Support.
Proceed.
Ms. Whitman, were you aware the case for here on the day involving Ashley Hughes, was the day involved?
Yes,
Okay, what's your position?
caseworker.
Okay, and what's been your involvement in this case?
That Ms. Spears filed for our services and we have worked to get the problem served with a complaint for child support. And now we're moving to set child support.
And you've been able to give the relevant information to set child support amount in this case.
Yes, we receive wages from the non-custodial parents employer.
Okay, does that meet your goal?
Yes,
And based on how many children?
one child, which is the oldest is 18 at this time.
And based upon the figures that you were seeing, talked about the family, it's calculated for the, let us say,
We're asking them to pay $7.26 per month.
that makes the federal child support about.
Yes.
Probably would you like to ask any questions? Like to ask her any questions?
She,
Need to ask her a question. You get to testify later if you want to. You know, the witness that we just had, would you like to ask her any question?
just about what should be.
He's asking about a waiver, and that is actually for the child, or for her services to the child. It's non-taxable income. And from what I checked into, it would not count towards mother's income.
What kind of waiver are you talking about?
Ms. Spears may be able to explain a little better.
It's a Michelle. It's called the Michelle P waiver, and instead of paying $250,000 a month to the facility care fund, they pay me, my budget is $32,000 to $34,000. And they pay me to provide care for her. It's a non-taxable waiver that is provided so that they can save Medicaid money and
Yeah, I got you.
better care for the child.
Okay. Okay, thank you.
No further questions.
When can I stay in consideration?
Judge, I'm well, there is, it's been always said he's in agreement.
Do you have any testimony you wish to offer, sir? Okay, ma'am, do you have any further testimony?
I would like three considerations. I would like three things to be considered.
Have you heard the amount that they suggested they order, and are you in agreement with that?
No, I would like three of the considerations to be made. Number one, I would like the date of competition to be considered, and he has made contributions since that day, and I thought very long as supposed, so that he can have credit. The second consideration I want made is that even though our son turned 18, he's just in the same field. What I have him do after he's out of school is, it's not, the onus of that is on me. But he's just in the same this year, and we'll be doing five for one meeting in my hall next till May. And then the third consideration I might want to make is our daughter requires an immense amount of physical personal care, and I provide that as well. But she's a little more costly than your average child too. And I have a budget here. It's not that much more. But I'd like him to like go half this, go and half it.
Well, let's go back to the first one again. You said you had three, and I didn't know they were gonna be that involved. What's the first one again?
The very first one is I'd like the date of competition.
Okay, which,
We had a hard time getting started when we went down to town, so there was a gap between our application and today. But there's not much we can do about that because it requires them to be served. Her application date was May.
There was. You all want to get you all separately disclose the payments and the
well, we're on number one right now.
That's.
So what they're saying is that the applicability of the child support cannot go back any further than before he was served. Is that what the county attorney is saying? So there's nothing I can do about that. Now, number two.
Number two, our son, even though he turned 18 on July 4th of this year.
Is he still in high school here?
Yes.
What is the law about that? Mr. County Attorney, what are you saying?
It's been said before, he's 18, and you go to high school, it's been said after he turns 18, I think it's more issues of trying to have a kid. That's not said.
So she didn't get it set before, if she got it set one day before he was 18, then it would go through the high school year. Do you have any law on that?
Yes,
You what?
we can get.
Well, I'm gonna hold that issue in abeyance, and whatever the law is, I'll do it. If, you know, if it's through the high school year, if it's 18, sir, do you have any objection to paying it through his high school year, or do you want some law on it? Well, I'm not telling you that's what you have to do, because I don't know,
Yeah.
and the county attorney doesn't know, but if you have some, if you will agree to do it through the high school year, if not, we'll just look at the law and I'll give you a later order. Would you rather us look at the law on it?
No, I'm sorry, saying.
Would you rather us to find out what the case law and the statute? Okay, okay, so we'll have the county attorney that issue us a letter on that, and whichever way the law is, that's what we'll enter on there. And what was number three? It's extraordinary cost. You have the dollars of special needs child. And is there, I'm not aware of any provision for additional costs for special needs. Are you?
Agree to the separation agreement with divorce or something.
Yeah, I'm not aware of that, but I would suggest that I would be subject to opening that back up if you get private counsel. The county attorney's obligation is to enforce the child support laws that are obvious like this, but if there's something particularly complicated, like a special needs child, additional thing, you'll need to get private counsel, look at that. But I won't rule against you, but I'll hold it, at this juncture, I don't have any law on that either, okay? Okay. Okay, thank you. Okay, you got an order, or you need to amend one?
I can agree this order, and something comes back, or needs to be amended, it's been amended.
Okay. Okay, thank you all very much. Okay, the next case is Nance versus Nance.
Oh, Judge, we have a reorder of that.
Cabinet versus Estes.
Judges, here, in this case, order to pay 150 per month and current, and the rest of the 500 would be paid by October 11th, the real 9/12.
Cabinet versus Kilburn.
Judge will pass the act on the non-custodial parents and rehabilitation.
Cabinet versus Davis.
This is this case, the range is 1264, we're at, not the civil parents order to pay 316 a month on current, 63 on arrears, less than $1,000 being paid by
Cabinet versus Gilliam.
This is a motion for default judgment. Here, and
You're on the Gilliam case.
here on the given.
Yes.
I need 70 testify.
Swear the testimony you're about to give us the truth, the whole truth, nothing but the truth, except that.
I do.
State your name.
Stephanie Wisdom, Clinton County Child Support,
What's your position?
caseworker.
Are you familiar with the case we're hearing today involving Kenneth and Field?
Yes,
Okay, and, maybe with it.
yes, I'm a caseworker.
Was the complaint called against Mr. Gilman?
Yes,
Okay, and was he served?
he was served on May the 11th, 2023.
Okay, and have you received any answer from Mr. Gilman?
No,
Okay, and did you figure out an amount?
yes, we based it on the 20,
And what is that?
$199 per month,
Okay, Jason, how many?
one child.
Okay, was this being given based upon the child support guidelines?
Yes,
So I have.
Do you have any questions you would like to ask? Mr. Gilliam is served and then I appear, so I will sign the order based upon the testimony given at this point. Thank you very much. Cabinet versus Osorio, is that right?
Yes, Your Honor. We have an agreed order on that case, Judge.
Cabinet versus Muse.
Judge, we have the agreed order in this case.
Yeah. I would be very surprised that if service of someone that may be avoiding service was determined whether or not they can get payment through that thing. I'd really like to see something on that because it would appear, I want to prejudge it, not say anything I see outside the presence of the leaders that's involved. Somebody to avoid service and thank y'all very much. The civil docket. Uh-oh. The DVO EPO docket at 1:15, so we're ready to go. Orton versus Orton. Get behind the microphone and speak up.
Judge, my client, Ms. Crystal Pfeiffer's motion for an order of protection against Anthony Gordon. She filed this motion on August 15th. She instructed that by today is to basis of the order.
You've already granted the protection order last month,
This
and
is
this is
a motion to vacate.
yeah, this is Ms. White's motion. to
Yes,
vacate.
it's on,
Yeah, she already got the order last month. This is a motion to vacate. What are your grounds?
Your Honor, I was served with a summons, which stated that the court date was not.
Are you saying they missed, wasn't given the right court date?
He was not, yes, he was given, today's date, actually, and that's the document that he brought to me, then later there, appeared to be another one drafted after, which he claims he was not served, and they were both turned in, so he did not have notice, to get here on that day, and he's requesting that the court consider.
Well, I'll hear it at the end of the docket, see what he has to say, and we'll take it between now and then we'll look at the things that are in the court. I'm not just going to dismiss it and not do anything. At least if he wasn't served properly, we'll have another hearing. McGall versus Barber.
I think we had agreed to get some dates with the DRC. But we've got some dates, we're just trying to iron out which one.
What is the issue? It's changing, modified dissolution, who's wanting to change?
My client was requesting that Mr. Barber, he is relocated and been a change in jobs. And so his ability to be able to be more involved with the children is definitely something that's material change. He's closer now than he was previously.
What's he getting now?
It's an odd schedule. It is. It's like so many days through the week. And
Well, I couldn't either.
no, they have, like, he gets 1 week Tuesday through Thursday, Tuesday afternoon through Thursday morning.
Did y'all sit down and work this out, you think?
We're gonna attempt to,
Well, I mean, but what does your client want?
my client would like to have more of an equal
Well,
time.
Okay, how's
He's
your,
also asking for the children, I think, to last weekend.
what?
He's asking to move the children last weekend. He doesn't reside in last weekend. Now, he's relocated into Wayne County, and he's now working at the sheriff's office in Russell County as opposed to last. I think it's up there in that area.
What does he want? Is he wanting to change school systems? He's not, is he?
No,
Okay, so Ms. White, that takes one problem off the table for you.
we had asked for modification of timeshare and.
What do you want? How much time do you want?
We're asking for an equal timeshare.
Okay, how's your client feel?
I'm not, she has filed a counter motion, there's issues regarding the children are heavily involved. And there's meetings where when he has, some of the children are not basically able to practice in games and they're penalized and so forth.
We can include that in an order.
Well, and some of the issue though is as a joint custodian, he's supposed to, or she's supposed to consult with my client as to what sport she signs the children.
I'm not gonna do that. I'm gonna say every child ought to be able to participate in every sport they want to or can.
The judge, if a parent signs, these are smaller children.
How old are they?
Middle school is middle school, and middle school.
Well, they're already recruiting them for other counties by the time they're in middle school now.
Yeah, I know, we have one child born in 13 and one born in 7.
He doesn't want to play certain sports.
He would like to have input as a joint custodian as to what sports, because essentially what's happened is she's signing up for sports that take away from his visitation time. Because right now, this visitation time is very limited to certain afternoons to the more.
There's no doubt about it that you can play travel ball and it's 14 hours a day. I would tend to think, you know, that my judgment, if it ultimately comes to me, just to give you some guidance, that she ought to sign them up for everything they can play, and then he gets to make up that time. In other words, they can't, she's making the decision on what sports they play. I really don't want a parent to decide on the visitation based upon what they want for them to the expense of the children. Now, is that some help to you in your negotiations?
I think
But-
agreements to make up. She just lets the children do what they enjoy. She doesn't really make the decision based on her wishes.
I'm sure she is on the side of the angels. All my clients were always too, you know, and I have no reason to believe she's not doing what's in the best interest of children. And I have no reason to believe that he's not interested in reaching some agreement on that, but y'all gonna have to sit down and talk about that at some juncture. And I'm just telling you that I do want him to make his time up. I want him to move closer to 50-50 if he's available. Unless you have any particular, now that they're older.
I know that they said that it was in Wayne County, but it's between Russell County and Pulaski. I forgot what that area is called in there. It's. He's relocated from where he was previously. That's where he lived.
Where does he live now?
Does he live like that?
Don't say Jabez. No, that's,
Yeah, that's what I'm talking.
yeah, I knew that's about.
And Judge, we agree for our clients not to be here. I'm kind of on the spot at the moment that I can't.
Okay, well, I'd like for y'all to, with this guidance I'm giving you,
It would help, yes. I don't
Okay.
know if we even wanted to sit down and get with the client.
well, let's do that. And then if you can't work it out, then you get a schedule with the commissioner, schedule it with the commissioner. And when you stay with the commissioner, tell the commissioner what I said I'm inclined to do, you know, and then if he finds other than that, I'll listen to his recommendations. Okay, thank y'all.
Thank you.
Claiborne versus Claiborne. It's your motion. So he's not, go through it for the record again on why it's not in compliance.
Judge, these parties went to the divorce back in 2021. They entered into a separation agreement August 17th, 2021. At which time he would have 75 days from that date to vacate the residence at 308 Dale Hall on Manor Road. He has failed to do so. It's been over 2 years at this point. And she's trying to work with him.
What other things are there besides that?
Just that. Just that. Whereas,
Well, you're gonna have a problem probably as far as the condition of the place, and aren't you, when you vacate, sorry, you know what?
I don't believe so.
Okay. Has he been served? Did you serve his previous attorney? How did you serve him today?
We sent this to, the address where he's living, where he sees his mail.
Does he work anywhere?
Yes. They all call it bodies.
Where is that located?
Where's the law, where's the law, where you go with the law?
Yeah. Are you in communication with him? No.
Well,
So you said, he's,
Like I said,
Have you talked to Mr. Thomas?
has he ever said why he's not moving out?
he just keeps making excuses.
Okay. Well, draw me an order, that, says that he shall vacate the property. Turn the property over to her. And, if he does not turn it over by October 10th, that he will be fined $200, if found in contempt, it costs him $200 a day, every day until it's turned over. I want to get, that's about, make it September the 28th, that gets in 2 weeks. September 28th, and then redocket it for him to show cause why this order should not be enforced. Follow what I'm saying? 28th to be out, $200 a day after that, and to be back here on that date. And I would make sure it was served to him. This order was served to him by the sheriff. Okay. So there won't be any doubt.
Did you say I'll be back October 10th if it's not out?
In October the 12th. That's the real date. 1:30. Correct. 1:30. Okay, thank you very much.
Thank you.
Thanks. Ingram versus Ingram.
Bill to file payment of fees and failure to.
How much does he owe?
The last order of the bill is $400.
What was that for? I said,
It was on the fees, the court actually added on an extra, last quarter.
okay, give me an order and hold and add another 150 on that. And hold him in contempt. And sentence him to 30 days in jail. And he purged himself by paying the $600. Okay, thank you. Warner versus Stearns. Anybody interested on Warner versus Stearns?
Just, that was here, the motion, our office spoke him, I believe he's withdrawing his motion, the city would be here to withdraw his.
Okay. Collins versus Moore.
Your Honor, that's Commissioner Sales, total sale motion for approval of the Curtis fees and costs.
What schedule?
We're using the any level schedule.
Yeah, there used to be an old schedule that floated around Monroe and Cumberland County at the time.
I'd like to go with that.
I've lost it.
I know about that, and I'd really like to go with that, but I don't think we can at this point in time, and I'm not asking for any extra fee. Probably so well, I will say.
How much you want?
30. Whatever it is, it's 29 plus cost, but we're trying to, we've got, we'll hold up on getting it closed, I'll interview it over.
Told them that the sale price was what?
Pardon?
The sale price was what?
46,000,
So you want a little less than 10%.
whatever any level said I could take.
Well, I know.
You want to amend that schedule, that's up to you.
No, I don't want them in the schedule. So I'll take it under advisement. Thank you very
I'll
much.
get rid of it. Thank you.
Mortgage assets management versus Arthur Brown and others.
Your Honor, that's mine. I'm standing in for mortgage asset management, asking for dismissal.
I don't think there'll be any objection to that.
No, Your Honor.
So if there's an order there, I'll enter it. If not, have them attend. Okay.
Yes, sir.
Cash
Thank you.
versus cash.
Motion that Mr. Ash, we've actually discussed it, and we've got to agree.
Well, that's good. So, okay. These are the, yeah, What's the agreed order say, so we get it on the record?
We have the agree order that they will have by Monday at 8 a.m.
You understand that, sir? Respond.
He and I have not had a chance to talk about it.
Well, say it out loud so he'll be here. So there's, tell him what it is. You tell him what it. Let's put it on the record.
The discovery.
You understand that, man? Okay, I just want to make sure that both parties heard it so that we meet out about it. Thank you very much. Wilson versus Sutton.
We need to sign it.
Okay, sure. Okay, right. Anthony Wilson versus Carla Sutton. Now, that's Joseph Venters, and they're gonna, he couldn't be here today, and I assume they wanted that passed over.
I,
Where is Mr. Cross?
I haven't spoken, they've not been back in contact with me. Have they called you, Melissa?
Yeah, they're the one that they call town. He said they're the trying to read the passage.
Y'all agreed to pass Wilson versus Sutton, correct?
Well, Mr. Venters needed to renotice that.
That's what I'm saying. You have no objection to that. Okay, that'd be fine. 21st Mortgage Corporation versus Ronnie Cole and others.
Good, I understand that. I think the role of Mr. Cross on one with the current.
Well, and I thought about the warrant for the attorney report. This is one of those deals where I've got to go down with the property and see if it's occupied, and I've not been down there yet. That's what's required on this deal, so I guess I just gotta do it. Make it all the time. You know, it's one of those, I'm ordering more to the unknown officer.
What are you doing this afternoon?
Getting ready for the football reunion.
Are y'all actually gonna play football?
Yeah,
Is that right?
they're-
Well, we better, you take him down this afternoon. To take a look at it then.
That's
possibility.
Be happy to go.
The possibility he won't be available to walk around then for Friday night.
These Cumberland County Panthers at one time.
Yeah, that shows you what the football program is like there, doesn't it? Okay, well, when can you get this done? 10 days?
Say 14, I'll do it next week.
I think the order tendered, says 10 days.
Okay, 10 days.
Thank you.
Okay. DRB Capital versus WW. Are you about to hear?
I will, Mr. Westman.
Let it be shown on the record that Ms. White has entered appearance, so her withdrawal will not be hasty.
What has happened is, we have followed this notice on his behalf, this is in regard to this water and liberty. I've talked to Tom Mazzell, who is the other counsel, and he was supposed to be in contact with you all, so it's happy, I couldn't know him to talk.
Is this where they tried to sell the annuity? Have you looked at the annuity?
And
It's lovely, isn't it?
if pursuant to his divorce, I think we can alleviate some of the financial burden he has by selling the marital assets to
To avoid,
where he would need to do that.
that would be a wonderful thing for both of them, I think. Okay, so you pass it to November,
Yes.
that'd be good. Mann versus Pierce. Okay, what do we have here?
Judge, this is the fact of custody action group that, Ms. Perigin has a motion on for the respondents trying to establish visitation. My client has been in custody of this child since approximately May of 2021, and they've not had any consistent contact. They've had ongoing legal issues.
Explain who the parties are.
My client is Avery Mann. She's actually the daughter of Philip Pierce. And the child at issue is Philip Pierce's child. My client's half sister that he shares in common with Miss Jane Pierce.
So she's had her half sister.
Yes,
Okay.
and essentially they have relocated,
Now, where have they been?
the judge, the child is going for a district court action. These folks have been.
Speaking to the microphone.
They have been living in Henderson County. They have been.
Tennessee or Kentucky?
Kentucky. They have been undergoing some treatments. They were placed in a treatment facility and they have completed.
Drug rehabilitation.
Yes, and after they have been able to gather their lives back together, they're requesting some time sharing with this child. And
How old is the child?
she is 9. Well, she was in their care for 9 years prior to the district court case, which placed her in this name. They were going to do a reunification plan and be back into their child's life. And they are in a understanding situation.
Yeah, now, look, I understand what you're dealing with. Now that I know the parties, what their relationship. Can you establish de facto custodian status if you have a child under a court order?
We can, if there's not anything ongoing, and there has already been an adjudication and a disposition back in 2021 in this case. So there was no
What
active
adjudication find that
The
they
adjudication found that my client.
Was
had
de facto.
custody.
legal custody or was de facto custodian?
Well, they don't make findings of de facto custodianship in district court through a DNA action. But because there's no outstanding court action ongoing in this case, then she meets the time required to establish statutorily as the de facto
The
custodian.
reason I asked you like that is I got burned on a case like that one time, and I don't do that much de facto custodial work. What happened to my client, I didn't think was right at the time, but because it was a motion in a court in Indiana or somewhere, they found out that the time didn't count. So I'll need, do you agree that the time, that the time is not told as far as the time?
Yes, Judge.
Okay, well, that's good. Now, here's what we need to do. I don't know the level of hurt, hostility, mother's protective situation, because I'm sure this Ms. Mann has got every indicia of being a protective mother of her half sibling, which she's been in charge of, so. If y'all sit down and try to work through any kind of limited visitation, okay, well, here's the thing I'm worried about. I'm worried about, does the child, and I don't want this question answered, does the child know where her parents have been? How does she feel about her parents? A 9-year-old can be rather advanced, or they cannot be advanced. 9-year-olds are different. So
She's 11.
she was 9 when it happened, so she's 11 now. Well, that even makes it more certain that what she thinks and feels about it, and any reunification must come carefully and not be foisted upon her. I think overall it's a good thing if she can find out that her biological parents have recovered and desire to resume some role in her life, and what that role will be. And what kind of custody order was issued in district court?
There was no visitation established with either of them.
To give her full custody of the
Yes.
child? Yeah. And I think that we have concurrent jurisdiction in some of those things, isn't that right?
That's correct.
Yeah. Well, I'm going to ask that we pass over this thing, and I'll let you do some prayerful consideration of what you want to do to allow this child to know that everybody loves her, which is the most important thing. And everybody wants to participate in their life, but that doesn't. I'm glad y'all have turned things around, but there are consequences. There are consequences. And number one thing in all these cases, no matter what the statutes say, ultimately, every one of them gets down to the best interest of the child as far as time sharing that. So I would ask that y'all try to work through it, see if maybe you can get the child to be seen by one of these unification counselors or something like that. Is she in council right now? Who's she in council with?
She goes to, communities, interventions, receives, every Monday.
Is that here? Yeah. And are y'all aware of the intervention that she's going through? Why don't y'all inquire of Ms. Delk if they have any services there that would help us take a look at everybody? And of course, I don't know y'all, don't know anything about you, don't have any reason to doubt you, but I'm going to be very careful if any unification comes back that nobody takes off with the child. I've seen very innocent looking folks that come in and everything, and next thing I know, they're somebody's on a milk cart, that listen, so we'll make sure that, so if you want to schedule it to come back, I don't think it really needs to go to the commissioner right now. I think we'll just see if we can work through it. If y'all will give us a written report on how we're advancing as far as the counseling is concerned, reunification, give us an order to that effect. And then if we reach an agreement before next month, then I'd be glad to sign agreed orders for some limited supervised visitation, depending on how the child is ready for it, Have y'all had contact with the child at all since you've been gone? So you communicate. I don't think anybody calls and will feel antiquated when I say if somebody calls somebody, do they email or text or any of those other social media things? Is that what you do? You call?
Watched the movie with just a few weeks ago.
Yeah.
Yeah.
Do you have a job? Where do you work? Where do you work?
I work in the city of Henderson, the water department.
Yeah. And do you have a job? Yeah. Yeah. You live in civilization. They got a drive on yourself. Yeah, well, that's good.
Judge, we do have a petition that's also seeking sole custody from circuit court.
I understand that. So, and it might be, but if you do get sole custody, there's still going to be some place for visitation and involvement. So I think working on that. Yeah.
To clarify, because I know she keeps saying reunification, but that's not what this petition is about.
Yeah, I understand. Well, ultimately, it's about what can be worked out. Yeah. Okay, thank y'all very much.
Thank you.
Wells versus Wells. Wells versus Wells. Speaker, you all right?
Good, there you sir.
I'm blessed.
You care if I stay on this side, because this is so I can see. Thank you.
Okay. This is Wells versus Wells.
Yes, Judge, it's my renewed motion asking for the court to reconsider on the previous ruling as far as jurisdiction. I know that the court found previously that in-person jurisdiction could be waived, given the response that my client's previous attorney filed. But we still assert that basically the court has to have subject matter jurisdiction as well as in-person jurisdiction. And by their own filings in their petition, she had only been a resident of Kentucky, even if she came in December the 15th for 30 days prior to filing this petition. So essentially, we're asking the court to dismiss against where it could be appropriately filed in Pennsylvania, where the residence is, or the alternative for it to be moved to Pulaski County, because now neither party is a resident of Clayton County. None of the children are attending school or
Would you agree to Pulaski County?
Would
Would you agree to Pulaski County?
I think Pulaski County could be a venue.
Well, if we can do, I think it would be more fair to everybody involved if we reach an accord on this, because it's going to take the Supreme Court of the United States for me to send it back to Pennsylvania. So I won't be doing that. So if Pulaski County is a venue, a jurisdictional thing that's is acceptable to all parties, they do have a family court up there. And I have full confidence. I know the family court judges up there. I don't know whether either one of y'all practice up there, but they do a good job. So I will sign an order transferring this to Pulaski County to end this. And you might have some validity. I don't know, but I think this is a way that everybody leaves a winner. Okay.
I'll submit the order to the court.
Okay. Thank you very much. Does that conclude the civil docket?
The fact that there's a 49 students.
Is that the EPO?
Yes.
Yeah, we're gonna get to you in just a minute.
It's confidential, so I don't know how you.
And I've got a confidential docket starts at 2. Let me take a short break here and I'll be right back. Now let's go off the record.
I'll put that in my notes. Yeah, it's 10:24. Now he's on. I'm gonna get on the phone so we can transfer all that. Do you want to inform me? Building on the rest of the bridge, not just like a 9 months. I don't know, well, we need to figure that out, and see if this. Yeah, yeah. Sometimes.
Okay, let's come back to order. We'll do Orton versus Orton. Could you send me give me a copy of the summons that he says was served on him? You take a look, have you seen that document there? If you take a look at that document has not been served.
And there's a problem.
Wait a second. Document's not been served.
Yes, Your Honor, that's what we found that he was.
Well, we got a document here in the file that says there was one served.
And that is.
No, let me finish here. And it was served and signed at the same time and the same date that has on that one. Okay. And there's some irregularities on that document. I can get some testimony if you'd like it, because the document creation number up on the right side is exactly the same as the document creation number on the one that was served. And I've been told by the staff and other folks that if there was a different document created, it'd have a different number on it. That one has the same number on it, which is impossible.
I don't know this is the one he brought.
I'm just telling you that I'm going to ask that the sheriff's department take custody of that document there. And I'm going to hold this in abeyance and refer this matter to the grand jury. Because it appears that someone has altered some documents here. I don't know who it is, but this was served appropriately. He did not appear here. And the document that you have, Ms. White, appears to have been altered. And I'm not saying you altered it. But if I find out that somebody altered an official document in this court, I'm immediately going to send it to the Commonwealth Attorney to do an investigation of this. Now, does your client want to withdraw his motion and move on, or what does he want to do?
Yes.
You need to. And leave the summons out here,
This one,
that one,
that's the one I was brought.
yeah. Let's go off the record for a second.